All right, sir, are you Robert Trahan?
Yes, ma'am.
And Mr. Trahan's cases are set for trial to begin with jury selection next Monday. There's 3 cases. We've got 25 DCCR 1094 charged with unauthorized use of a vehicle, 25 DCCR 1317 possession of a controlled substance, and 25 DCCR 1536 charged with evading arrest or detention with the use of a vehicle. And what is everyone's announcement?
You first.
State's ready.
We're ready. Judge, I do have, I was special set in Orange on a bond case. So I don't know how you want to handle that, but I was special set before this case was set.
Is there a protection order or it was just a setting? But they're on bond?
Yes,
In whose court?
Townsend.
Okay, talk to them and we'll go from there.
And I
But
have a
if,
pretrial in that court tomorrow. So if whatever happens here, if I know before tomorrow. then
yeah,
I should-
you'll know the number today of your case. And so it looks like the state, well, Mr. Coleman, which case would the state elect to proceed on?
The evading judge.
All right, so 1536 would be the numbered case. And it looks like the state has filed a notice of intent to introduce extraneous. Is that just for punishment or is it any enhancement?
It's for punishment, judge. The indictment has already enhanced this case to 25 to 99, if I'm not mistaken.
That's correct.
And the
And
state.
it looks like the previous plea bargain rejection, when we were here in March, was for 7-year term. Is that correct?
Yes, judge.
And so, Mr. Trahan, there's only a couple of cases left set for trial, so it's very likely that yours will be close to the top of the list to go to trial next week. I want to make sure that's what you want to do, understanding that if you're found guilty and if those prior convictions are true, that you would be looking at a minimum of 25 years in prison up to 99 years or life.
Yes, ma'am.
Okay, and it looks like the state has also filed a motion to cumulate, which means you've got 3 cases. They're all from different offense dates. And so if you're found guilty on one, then we could go to trial on the next one. If you're found guilty on that one, the state could ask that any sentence you get, if you're found guilty, be stacked on top of each other in all of these cases. Do you understand that as well?
Yes, ma'am.
Yes, sir.
And not to get into the facts of the case, have no doubt Mr. Hickard has gone over the video with this defendant, but judge, it's captured on video.
And have you looked at the video?
Yeah, it's a misunderstanding.
Okay, I just want to make sure you've seen it, y'all discussed it, and so we will number the case. I'll number it as soon as docket's over, and we'll let you know so you know what to do about next week as well.
Thank you, Judge.
All right, thank you. You can go back with the bailiff. Mr. Gertz on Dalton Batiste. All right, you're Jason James. Okay, so. Mr. Jones has 2 cases. We've got cause number 26 DCR 0340, which is a new offense of possession of a controlled substance, a 2nd-degree felony. And then we've got a motion to revoke, which is in cause number 23 DCCR 0390. And the underlying offense in that case is unlawful possession of a firearm by a felon. Looks like we were here. Initially, there were pleas of not true, and then in May, we came back on the motion to revoke. He changed his pleas to true to counts 1 and 2. We set a hearing today. The agreement is for a cap of 8 years in each of these cases. Is that correct?
Correct, Judge.
Yes, Your Honor.
Okay, and he already pled guilty on the other one as well.
Yes, correct.
Got it. Okay, I have the original pre-sentence report from that unlawful possession of a firearm case, but I also have an updated report that was prepared. And have you all had an opportunity to review that update?
Yes, Your Honor.
Any additions or corrections?
None that I'm aware of, Judge. Not mistaken.
I also have just looks like 3 pages of few incident reports. If you all had an opportunity to review those as well.
Yes, Your Honor. I have.
All right, Mr. Parker, you may proceed.
Your Honor, we're asking that the court keep him on probation. He wants the opportunity to prove he can complete it. We're asking that you let him serve the ISF track cognitive to make him help better decisions. And also put him in the JCDI program where he's tested regularly. And I mean, then it's, we know whether he's using drugs, but drugs has apparently been the problem on his underlying case. I think he wants to address the court, Judge.
Give me just a second and then I'll let you do that. I'm printing a PC. Go ahead, Mr. Jones.
Yes, Your Honor. I've had time to reflect on what brought me here before you today. I take full responsibility.
This case just turned brutal. The judge
and
says
also
intoxication, fleeing the
putting
scene, and a death
in the
demands serious
JCDI program
punishment.
where he's tested regularly.
Was 15 years justified?
I mean, then
And if given a second chance to complete my probation, I just need a chance to prove to you, my family, my children, I can be not a liability to my community, but an asset. I had things going on before I got locked away and started a business, and I'm a single parent. Getting my license and my diploma like you asked me to do. So
Okay.
just asking for another chance to get that done.
In just a second to review this and then I'll let you go, Mr. Nichols. Mr. Nichols.
Judge, when we entered the pleas of true, it was right before we were about to have a hearing to prove up the new allegation. I'll summarize for the court what that would have shown. Back in June of last year, only about 3 weeks after he started probation, he was detained in an empty lot off of about a block off of Calder, downtown Beaumont. Not coincidentally, about a block also or two away from Henry's place. And what he had been doing was selling crack cocaine. He was one of several individuals in an empty lot that had an active trespass warning on it. And Beaumont police would have testified the reason they went to that lot and detained people that day was because they had received or been informed by several people that had been stopped that week with crack cocaine that they bought it from him. And so when he stopped, he's sitting in a lawn chair in this empty lot where he's not supposed to be, with a plastic grocery bag underneath the chair. And in that chair is about 11 grams of crack cocaine along with synthetic marijuana and I believe actual marijuana. And so he had gotten probation for the charge of unlawful possession of a firearm by a felon. His original felony case was a state jail from Harris County. And then almost as soon as he's put on probation for that, he's in the street selling crack. I don't see how we would keep him on probation. I think 8 years is appropriate. On both these cases, Judge, it's a second degree amount. So the new case that he pled guilty to.
So here's the issue that I have, Mr. Jones. Mr. Parker's argument that there's a drug issue. It's not a drug use issue. It's a drug dealing issue, which is what the underlying case had to do with as well. When you were pulled over for that and you got the case of the unlawful possession of a firearm by a felon, you were found in possession of the Glock 9mm with a chambered round, green marijuana in the center console, another bag in the cup holder, and then another 4 bags and a scale and
She wanted another chance, but the judge fired back. This was already a second chance. Can probation survive repeated violations?
a second firearm in the car, again chambered with rounds in it. Another magazine under the driver's seat and another magazine in the center console. Now here we are, you get probation for that, and 3 weeks later, you're dealing drugs again. So it's not a matter of I want to do better. It's you literally got probation and 3 weeks later pretty much just thumbed your nose at me and said, I can do what I want and I'm going to go do what I want and sell drugs where I'm not supposed to be. So at this time, I'm going to find and cause number, let's see, what do we have? Hold on. 26 DCCR 0340, find that you entered your plea of guilty freely and voluntarily. Find has sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of possession of a controlled substance. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0390, going to find that you entered your pleas of true to count 1 and 2 freely and voluntarily. Find those counts true. At this time, find sufficient evidence to find you guilty of unlawful possession of a firearm by a felon. Find you guilty of that. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read it. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. All right, you can go back with the bailiff. And this is cause numbers 24 DCCR 0404. Mr. Harris is charged with murder, and 19 31482 charged with possession of a controlled substance. What is the announcement?
We have a tentative plea agreement, but it needs to go through the channels before, so we just need whatever the state needs.
And Judge, the court has been patient with us with regard to his Harris County case. That was obviously resolved. Not quite what we had anticipated that resolution would be with respect to also taking care of this case. But we did bring him back. Those cases are pending. I extended a somewhat of an offer to Mr. Burbank with the understanding I needed to know some specific information before I took it above my head, which he's now informed me that would be an equitable resolution. So I just need to get a little bit of approval for that, and hopefully we can wrap it up just at the next plea setting. I mean, maybe not a definite to plea, but we're close.
Okay, let's reset it 2 weeks. All right, we'll reset your case 2 weeks. Kavon Saunier, good morning. Are you Kavon Saunier?
Yes, ma'am.
And Mr. Saunier, you're charged in cause number 25 DCCR 1530 with a first-degree felony offense of aggravated assault with a family member. And
A guilty plea can carry massive consequences. The judge warned that non-citizens may face deportation. Did she fully understand the stakes?
that's from September 28th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years, up to 99 years, or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you signed with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty or a 20-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? And I did make the adjustment on the plea bargain rejection from a second to a first that he's been admonished. Is there any reason to believe that that offer would change?
No, Your Honor. I know there's some questions with the complainant, that he's aware of because he talks to her on the phone all the time, but the state's offer's not changing.
Okay. So you're talking to her on the phone from jail? Okay, so I'm ordering today that you are not allowed to have any contact or communication at all with Delaney. Is it Saunce? Okay, you cannot talk to her. You can't call her. You can't send her letters. You can't send messages through anyone else, period. Do you understand? If you're caught doing that, things are just going to get worse, okay? All that information will be information that a jury can hear or I can hear. Mr. Nichols will hear it. So I'm ordering you now that you are not allowed to do that. If we catch you doing that at the jail, I can order that you have no telephone and none of those things. Do you understand? Okay, all right, go back with the bailiff. Case set for trial.
Thank you, Your Honor.
Good morning. Are you Timothy Bassard?
Yes, ma'am.
And this is cause number 26 DCCR 0276. Mr. Bassard is charged with aggravated assault with a deadly weapon. And 26 DCCR 0600 charged with murder. And what is the announcement?
Judge, I talked to the parent this morning and we have discovery, we have media. However, we are still waiting on a number of different lab reports. And for sure the murder, and I think maybe also the aggravated assault.
Okay.
Specifically DNA.
Okay.
And so I think we're kind of at a spot where we need to kind of stall a little bit until we get those reports in and get the files in.
That's correct, Judge. We're working on some things.
Okay. Any idea of?
I don't know, but I'll look into it and see if they can step it up or anything.
Okay, if you'll, obviously since he's in custody, if you'll take a look at that, we'll reset it so that you guys can work on getting that DNA, those results back, and then we'll, see where we are. We'll do about 45 days. But if you'll check on it, see if they can kind of bump it up if possible, that'd be great.
I will, Your Honor.
Thank you. All right, you
Yeah,
go back to
listen,
bailiff.
thank you, ma'am.
See, Mr. Eckhart, you have Robert Trahan, 3 cases. All right, sir, you Jacoby and Dorsey. And this is cause number 25 DCCR 1896. Mr. Dorsey is charged with manslaughter. It's my understanding Mr. Radford was able to receive this morning the media and any videos and things like that. And so what I'm going to do is reset the case for about 30 days. Mr. Radford will be out there to go over all of that with you, and then we'll get an announcement at the next court date now that he has everything, okay? All right, you can go back with the bailiff. Lively Stratton.
Folder, he was back there and I didn't know it, and he thought this caused me to have a heart attack.
Good morning. Are you Darius Rigsby?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You know, Your Honor.
Mr. Rigsby, in cause number 25 DCCR 1089, you're charged with a state jail felony offense of an
2 forgery convictions brought probation, but 1 warning stood out: ignore restitution and prison could follow. Is probation really freedom?
authorized use of a vehicle from May 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rigsby is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you did waive your right.
He rejected the plea offer and chose trial. That means the courtroom battle is coming. Would you take the deal or risk everything before a jury?